Hi there. This is Larry Donahue with Law for Small Business, and you're listening to our video series about trademarks. I'm going to talk at a high level about trademarks and what they are. And the first issue is you've probably seen the little R symbol on names or logos. And what the R symbol means is the trademark is actually registered with the U.S. Patent and Trademark Office. You cannot use the R with a circle around it with a mark if it's not properly registered. That is actually an offense that can create all kinds of problems for you. The TM, if you've seen that, instead of the R symbol, you've seen the TM. That you can use. And TM simply means you're telling the rest of the world you're using it as a trademark, but it's not registered. So with the R symbol, it is registered. TM symbol, it's not registered. It's really that simple. Now, let's talk about trademarks a little bit more. If you've typed trademark or trademark lawyer or register a trademark at Google, the chances are the first few pages of results are they'll register some kind of company claiming to register your trademark for $69, $99, or something like that. What you need to understand is registering a trademark is actually really hard. It's easy to fill out the documents and send them in. What's hard is filling out the documents correctly and then getting them approved by the U.S. Patent and Trademark Office. So these companies that are willing to do it for $69 or whatever, they're just filling out forms and sending them in. That's all they're doing. And what's happening is over 80% of the applications that get submitted are rejected by the U.S. Patent and Trademark Office. So think about that for a moment. If you're going to just simply fill out those documents and send something in, you have an 80% chance that your application is going to fail. And there's two problems. One is the fees are non-refundable. The second problem is it takes 4 to 6 months to hear back from the Patent and Trademark Office. So while you think you have a good name, and you go off and print cards and put your name on boxes or etch it in glass or whatever it is you're doing with your trademark, your brand name, you may find in 4 to 6 months, you have an 80% chance of finding out in 4 to 6 months that you have a problem with that trademark. And there's many reasons, hundreds, why the U.S. Patent and Trademark Office might reject a trademark application. But there's two primary reasons. One being descriptive. The second one being it's likely to confuse with another trademark out there. So let's talk about descriptiveness first. Descriptive means, let's say you are in the business of selling elevators and you want to use the word elevator. It's the elevator company. That would be rejected, and because it's descriptive of what it is you do. But that same word applied to something completely irrelevant or different would be totally fine. So if you had a fruit company and you wanted to call it the elevator company, that would be fine. If you had a computer company and you wanted to call it the elevator company, that would be fine too, because it's not descriptive. So the problem and challenge here is coming up with a name that's not descriptive for what it is you do. What would be an example of a non-descriptive name other than the two that I have given you? The real world examples would be like Amazon. The company Amazon, it's a river. It has nothing to do with the actual product or services that they provide. Another example would be Apple or Apple Computer. Yes, computer is descriptive, of course, but the Apple is not. So those would be examples of names that would probably pass, at least from the descriptiveness perspective. The second one, likelihood of confusion, is much more difficult. When I talk to clients, they usually say, oh yeah, I've looked and my mark is available. What they mean is, I've looked for that exact word and I didn't find the exact word or phrase in the trademark database. And so therefore, I think I'm okay. And the answer is no. It's a likelihood of confusion that matters. So if there's the same meaning, the same look, or it's pronounced or spelled the same way, you could potentially have problems. And with a translation. So let me give you an example. Redbox. You've heard of Redbox before, the DVD box you might find out in front of a Walgreens or supermarket. Well, there was another trademark that was attempted to be registered, and I don't remember the exact name. I should have looked it up before this video, but so be it. I believe instead of Redbox, switch those two words around, and it was cubed rojo. So think about that for a minute. Compound word, red box. Switch those two words around, box red. Rojo is Spanish for red. Cubed is synonymous for box. That was deemed a likelihood of confusion and rejected by the U.S. Patent and Trademark Office. So the point I'm trying to make is a likelihood of confusion is very difficult. So you take a typical word, let's go back to elevator, and let's say there's a company out there that instead of using E for elevator, uses the number 3. That would still be a likelihood of confusion. So there's a lot of ways that a word or trademark out there that would be very difficult to find could be a problem for you in registering your trademark. So just to quickly address some questions out there, if you pluralize a word that's not pluralized or vice versa, doesn't matter. If there's a trademark out there that's 2 or 3 words and you're just moving them together, doesn't matter. Likelihood of confusion. Similarly, if you're swapping words around or maybe just adding one word, not enough. So it's a very difficult thing to get past the likelihood of confusion. A simple exact match search is not going to do enough for you. Now let me tell you one thing that can help you a little bit, and that's called a class code. Class codes address industry channels. So if you're selling cosmetics, that's one, cosmetics and perfumes, same class code. But it's different from clothing, which would be a different class code. Shoes would be maybe, I'd have to look that up, maybe a different class code or at least a different description within a class code. But the point I'm trying to make is if there's a trademark out there that is very similar to yours, but it's in a different class code, that's okay. So, for instance, if there is, let's use the elevator company again. So there's a fruit company called the Elevator Company, and you want to use the word elevator for performance cars. That's probably okay. Different class codes, that's going to be fine. Now there's exceptions to that, and that's famous marks. So Apple Computer, FedEx, Amazon, they're considered famous. And even if they don't have a trademark in a class code you're interested in, you probably will still have issues. So the point I'm trying to make with all of this is if you're serious about your trademark, you probably should work with an attorney, and you should probably do that an assessment or a search first before you go forward. Now my firm, we charge $349 to do what we call a trademark assessment. And we find a ton of reasons why our clients should not register a particular mark. It frustrates a lot of clients, I'll admit it. However, what they're getting is at least they know what the problems are, and then they are able to pick a different mark and have a much higher chance of success before they register that trademark. That they don't have to wait 4 to 6 months either. The only problem with our assessment, as well as anybody's, is it's not 100%. All I could do is potentially find problems, and if I don't find problems, all I can tell you is I don't think there are problems, but there still could be. And the U.S. Patent Office does surprise us on occasion. I'd be lying to you if I told you otherwise. Finally, what I want to mention is this whole trademark process. You may be thinking, I got a brand new business. I don't need to be dealing with this kind of stuff right now. However, I got to tell you, a lot of clients come to us because they're getting sued for trademark infringement. What does that mean? It means that they went ahead and came up with their own name and they didn't do the trademark search. The reason they didn't is because they said, well, I don't want a trademark. Fair enough. But if somebody else does have a trademark and then you start using it, they can sue you for that. So you really owe it to yourself and your business before you go start pasting your trademark or logo on your service or product. Do a trademark search, even if you don't want to get a trademark. Although I'd strongly encourage you to do that because it's so darn inexpensive. So point being is trademarks really are an indispensable part of your business, and you owe it to yourself to learn a little bit more about this and to deal with a trademark attorney. Don't deal with these fly-by-night companies on the internet. They're going to tell you they've registered 1 million trademarks, and it's probably true. But over 80% of those registrations have failed. And so everybody's spending money with these companies, and frankly, they're getting nothing for it. The fees are non-refundable, and it takes time, as I had mentioned before, and you're basically back to square one. So work with a trademark attorney, and you owe it to yourself to spend a little bit more money to get the right service and product that you need. Any rate, thank you for talking or listening. My name's Larry Donahue with Law for Small Business. If you have questions, you can email us. You go to /contact on our website, which is www.l4sb.com, or you can call us 505-715-5700. Thanks for watching.